Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everyone! What a humongous week of cases. Not gonna lie, I kinda suspected it was coming due to the last few weeks, but did it have to be this big, and did it have to be the week that I was moving? I beseech ye, immigration gods, to look down more favorably upon me in the future. To this end, I have sacrificed an A-file for your pleasure, burning the multi-volume packet around a bonfire like the pagans of old. Tune in next week to see if it worked. Also, congratulations to all 19 new immigration judges, including KKTP alumni and now I guess former University of Houston law professor, Judge Jeffrey Hoffman. May it please the court. 11 cases to go. Starting out with a great one from the 4th. Sorto-Guzman v. Garland, published by the 4th Circuit on August 3rd, 2022. This case is about past persecution. Ms. Sorto-Guzman and her young son fled El Salvador for the United States in 2016, quote, following death threats and violence at the hand of the Mara 18 gang due to Ms. Sorto-Guzman's Catholic religion, end quote. CBP detained them at the border shortly after they entered the United States, and CBP placed Ms. Sorto-Guzman and her minor child in removal proceedings after she passed her credible fear interview. As the basis for her claim, Ms. Sorto-Guzman explained how she had been a devout Catholic all of her life, and that in December 2015, Mara 18 gang members accosted her as she was leaving church and while she was wearing a crucifix. Quote, the gang members tore the chain from her neck, hit and kicked her, and threatened to kill her if she ever wore it or attended church again. Ms. Sorto-Guzman stopped attending church after the attack, fearing the gang and their threats, end quote. A few weeks later, gang members accosted and sexually assaulted Ms. Sorto-Guzman. She screamed, and quote, the gang members threatened to kill Ms. Sorto-Guzman and her sister if Ms. Sorto-Guzman did not join the gang and start living with them, end quote. A few weeks after that, the same Mara 18 members broke into her house with guns, quote, viciously beat Ms. Sorto-Guzman, threatened her life, and robbed her, end quote. Her neighbors called police who took hours to arrive. Quote, the day after, a gang member called Ms. Sorto-Guzman, warning her that she would regret making the report to the police and that they would soon kill her, her son, and her sister, end quote. An immigration judge believed Ms. Sorto-Guzman and held that indeed, at least one of the threats and harms occurred on account of a protected ground, Ms. Sorto-Guzman's religion. So that's a big win right there. But a bit perplexingly, as written by the 4th Circuit, the IJ then held that, and quoting the IJ, quote, the physical mistreatment in the December 2015 assault, even when considered along with the threat that never came to fruition, simply does not rise to the level of persecution, end quote. The IJ concluded that some of the other incidents, like the beating, were not on account of her religion, and so they couldn't be past persecution either. No nexus. That means Ms. Sorto-Guzman retained the burden to establish a well-founded fear of future persecution, which the IJ concluded she had not shown, because it was a one-off incident, that church incident, making it, quote, highly improbable that she would be threatened with religious persecution if she returned to El Salvador, end quote. The BIA affirmed all of it, as well as the IJ's denial of withholding of removal and cat protection. The Fourth Circuit did not, particularly as it was reviewing all of this de novo, rather than under the deferential substantial evidence review, because, quote, whether the maltreatment a non-citizen suffers amounts to past persecution is a question of law, end quote. Rock on. And it was pretty straightforward to the court. The Fourth Circuit has held that a credible death threat rises to the level of past persecution. Many circuits agree, too. And here, the IJ concluded that at a minimum, a credible death threat occurred in December 2015 on account of Ms. Sorto-Guzman's religion. All you need is one. That's past persecution on account of a protected ground, meaning that the burden shifted to DHS to rebut Ms. Sorto-Guzman's presumptively well-founded fear. Nothing more was required of Ms. Sorto-Guzman. Quote, the threat of death alone constitutes persecution, and an applicant is not required to additionally prove long-term physical or mental harm to establish past persecution, end quote. Emphasis by the court. Then they said it again, and emphasized alone again. I believe the Fourth Circuit is trying to make a point. To the court to hold otherwise, quote, would not only defy our precedent, but would also create an untenable standard for asylum seekers, end quote. Even if the other incidents of harm testified to didn't have a nexus to Ms. Sorto-Guzman's religion, and the Fourth Circuit isn't deciding that here, they still at a minimum corroborate, quote, the seriousness of the threat Ms. Sorto-Guzman received, end quote. Makes sense to me. And to the court, quote, it makes good common sense that any subsequent threats from the same persons, regardless of why they were made, would make Ms. Sorto-Guzman permanently afraid to express her religious beliefs, end quote. Love the logic. Ms. Sorto-Guzman, quote, has established she was subjected to past persecution in El Salvador, end quote. DHS had the burden to rebut, and the IJ and BIA erred by not applying that burden shift. Remand. Congratulations to none other than AILA National President Jeremy McKinney on the big win. With great quotes, too. Hail to the chief! And that is Sorto-Guzman v. Garland. From the Fourth Circuit, we go to the Eighth Circuit with Gutierrez-Vargas v. Garland, published by the Eighth on August 1st, 2022. This case is about particularly serious crimes and Convention Against Torture Protection, and does not mess around, opening as follows, verbatim. Quote, Mr. Gutierrez-Vargas, a native and citizen of Mexico, entered the United States without inspection in 1979. One evening in June 2013, Mr. Gutierrez-Vargas and his family returned home to find that his daughter's boyfriend, Milton Miranda, had murdered a man in their house. To prevent Mr. Gutierrez-Vargas from calling the police, Miranda took his phone and threatened to kill his family. He then told Mr. Gutierrez-Vargas to help him bury the body. The two men moved the victim's body to the back of the house, where Miranda, using Mr. Gutierrez-Vargas's tools, dismembered the body while Mr. Gutierrez-Vargas dug a hole in the backyard. With Mr. Gutierrez-Vargas's daughter's help, they put the body parts into garbage bags, which they then buried in the hole. End quote. I don't even know what to say. Mr. Gutierrez-Vargas was arrested after his daughter herself went to the police, and was eventually convicted of lots of related crimes and sentenced to at least 15 years imprisonment. He served some of it, and DHS sought his removal. Mr. Gutierrez-Vargas applied for asylum and related relief, primarily based on the fact that Miranda was a member of the Zetas International Criminal Organization in Mexico, and that Miranda had gone so far as to, quote, carve a Z into the victim's face, end quote. Convicts came up to Mr. Gutierrez-Vargas in prison saying that they knew everything about his crime, and they threatened him. and Mr. Gutierrez-Vargas believed that Miranda had Zeta contacts in Mexico. An immigration judge found the crimes particularly serious and then denied cat deferral on the merits. The BIA affirmed. The Eighth Circuit first affirmed the BIA on the particularly serious crime stuff. And I'm not going to lie, Mr. Gutierrez-Vargas had a difficult argument, asserting that, quote, the IJ erred in concluding that his crime of dismemberment was against a person because the victim was already deceased, end quote. Play with the cards you're dealt, I guess. But even if that was the case, the Eighth Circuit agrees with at least the Third Circuit that particularly serious crimes need not be against a person. In any event, the Eighth Circuit believed that it couldn't reweigh evidence on the issue given a jurisdictional bar applicable when criminal offenses, such as this one, exist. Turning then to cat deferral, the only form of protection that Mr. Gutierrez-Vargas was eligible for. The Eighth Circuit just didn't see a case, deeming there too many unknowns in the claim. Also, Mr. Gutierrez-Vargas, quote, and his family had not been contacted by Miranda or anyone claiming to be associated with him since 2013, and Mr. Gutierrez-Vargas did not establish any connection between his home state in Mexico and Miranda that would support his fear that Miranda could carry out threats there, end quote. Plus, Mr. Gutierrez-Vargas still has some family living in Mexico unharmed. The Eighth Circuit concludes by noting that indeed, quote, an applicant's credible testimony may be sufficient to sustain the burden of proof without corroboration, end quote. So right on. But found that claim not established here. Mr. Gutierrez-Vargas, therefore, lost his case. And that is Gutierrez-Vargas v. Garland. Next is Perez-Camacho v. Garland, published by the Ninth Circuit on August 1st, 2022. This case is about motions to reopen and criminal convictions. Mr. Perez-Camacho is from Mexico and became a lawful permanent resident in 1985, possibly through President Reagan's amnesty. Who knows? But in 1997, he pled guilty to the oft-appearing crime of inflicting corporal injury on a spouse in violation of Section 273.5a of the California Penal Code. DHS charged Mr. Perez-Camacho with removability in 2005 under INA Section 237A2EI as a non-citizen convicted of a crime of domestic violence after admission. And actually, he was eventually ordered removed in absentia. Looks like he failed to appear unintentionally, though. He moved to reopen 2 months later, but the immigration judge denied that motion. And in the United States he remained, until 2018 when he filed a Pereira-type motion to reopen based on deficiencies in the notice to appear. While that was pending, it appears, Ms. Perez-Camacho got his 1997 conviction modified due to, quote, constitutional defect, end quote, namely, ineffective assistance of 1997 criminal counsel in California. He then repled to domestic battery under Section 243E1 of the California Penal Code. And I guess under Ninth Circuit precedent that crime doesn't make an LPR removable? I don't know. The decision doesn't say, but it sure seems that must have been the argument. The BIA ultimately denied the motion to reopen. At some point before the BIA, it seems, the deficient NTA stuff kinda went away, so this was all about the BIA's refusal to reopen, notwithstanding the vacated conviction. The BIA deemed that motion 13 years untimely, and held that the sentence modification did not toll the motion to reopen filing deadline. The BIA then refused to exercise its sua sponte authority to reopen. No citation to Attorney General Barr's matter of Thomas and Thompson decision and whether this sentence modification in California has effect for immigration purposes. Also, to my knowledge, no court or the BIA has yet relied on matter of Thomas and Thompson substantively to so rule. Unless I'm misremembering. It happens. Anyway, to the Ninth Circuit it went, and remained, because the court ruled against Mr. Perez-Camacho. First, although the Ninth Circuit doesn't cite to Thomas and Thompson, it does footnote that, quote, if a conviction is vacated for reasons unrelated to the merits of the underlying criminal proceedings, it remains a conviction in removal proceedings, end quote. So that's pretty similar to Thomas and Thompson. Sigh. It need not be this way, and Attorney General Garland can step in. and explain what happens for immigration purposes when a state conviction is modified or clarified or vacated, all of these things. That's the bad. The good is that the Ninth Circuit states that, quote, if the conviction was vacated or modified because of a procedural or substantive defect in the criminal proceedings, this may lead the BIA to grant the non-citizen's motion to reopen the immigration proceedings, end quote. But even if that was the case in this case, it was not sufficient to warrant equitable tolling here. Recall, motions to reopen such as this must be filed within 90 days of the removal order. This one was not, by many years. To equitably toll that deadline, the non-citizen, quote, must have been prevented from obtaining vital information bearing on the existence of the claim despite the exercise of all due diligence, end quote. Ineffective assistance of counsel by prior counsel can cut it, but the due diligence component requires an inquiry into, quote, when a reasonable person in the non-citizen's position would suspect the specific fraud or error underlying her motion to reopen, end quote. The Ninth Circuit agreed with the BIA that that standard was not met here, as Mr. Perez-Camacho, quote, provided no basis as to his reasonable efforts to pursue relief with the criminal conviction during the 21-year period after his conviction, nor provided any explanation for such an exceedingly long delay, end quote. The Ninth Circuit held, largely in passing, that it didn't matter that a, quote, gross miscarriage of justice, end quote, might occur absent reopening, because that's a standard applicable pretty much only in the reinstatement of a final order of removal context. We discussed some cases on that in the Ninth Circuit 2 weeks ago. Lots of case law discussed in this decision to fairly summarily hold that Mr. Perez-Camacho lost his case. But there's this. I'm always discussing decisions on the podcast whereby the courts hold that they can't review the BIA's decision not to reopen proceedings sua sponte. But that's not technically true, at least in the Ninth Circuit. According to the court, quote, we may exercise discretion for the limited purpose of reviewing the reasoning behind the decisions for legal or constitutional error, end quote. A difficult standard to meet, but a standard for sua sponte reopening review, nonetheless. And that is Perez-Camacho v. Garland. Sticking with the Ninth Circuit, we have Troncoso-Oviedo v. Garland, published by the Ninth on August 5th, 2022. This case is about good moral character. Mr. Troncoso-Oviedo does not have authority to be in this country, but he has been here for 22 years. In 2018, he was convicted of aggravated DUI in Arizona, for which he received a term of imprisonment sentence of, quote, 4 calendar months with a pre-sentence credit for 183 days, time served, end quote. If anyone's paying attention, that means Mr. Troncoso-Oviedo spent 3 days over 6 months in pre-trial detention and was credited for that time as part of his sentence, even though the sentence was less than 6 months. He spent more time in pre-conviction detention than resulted from his actual conviction, and he's being credited for that additional time. Many of you may see where this is going. Man, these cases are like law school exams sometimes. It's going here. Mr. Troncoso-Oviedo applied for non-LPR cancellation of removal in removal proceedings because he had been in the U.S. for over 10 years, and he asserted that his removal would cause exceptional and extremely unusual hardship to his qualifying relative LPR or U.S. citizen relative in the U.S. But Mr. Troncoso-Oviedo cannot even apply if he doesn't have good moral character. Good moral character is defined at INA Section 101F. Non-citizens can be deemed to lack good moral character even if the reason isn't listed at that statute. Acute ira gotcha. But if the non-citizen falls within one of those statutorily defined categories, they're pretty screwed. One of those subsections, INA Section 101F7, makes a non-citizen lack good moral character if they have, quote, been confined as a result of a conviction to a penal institution for an aggregate period of 180 days or more, end quote. Well, the IJ and the BIA concluded that the ball of wax presented here satisfied that statute. But the Ninth Circuit did not agree. Quote, the sentencing order is not ambiguous. It imposes a 4-month, 122-day sentence, end quote. Everything else from the Arizona Criminal Court just discusses the credit Mr. Troncoso-Oviedo received. That is, he didn't need to serve any more jail time because he was already over the 4-month sentence. And so concluding, that kind of means that the Ninth Circuit decided not to defer to a BIA decision that's older than me. Matter of Valdovinos, which holds that, quote, time a non-citizen spent incarcerated prior to his conviction is considered time served as a result of his subsequent conviction, end quote. Or that is to say, the Ninth Circuit distinguished matter of Valdovinos, because in that case the pretrial detention was included in the conviction. And so the BIA held that yes, that time counts when calculating imprisonment for a conviction, because it was part of the conviction. Here, in contrast, the pretrial detention was only part of the conviction up to 4 months. The additional 2 months in pretrial detention was essentially just additional because it was over the sentence actually imposed ultimately by the criminal court. So it's not really that the Ninth Circuit didn't defer to matter of Valdovinos, it just distinguished it. More importantly, it's going back for further analysis regarding good moral character and Mr. Troncoso-Oviedo's eligibility for non-LPR cancellation of removal. There was another issue. Before the immigration judge, Mr. Troncoso-Oviedo's former counsel had waived his application for asylum and related relief in lieu of the non-LPR cancellation of removal application. Didn't have to do it, but he did. Mr. Troncoso-Oviedo's petition for review counsel asserted that the IJ violated Mr. Troncoso-Oviedo's due process rights by not asking him directly if he wanted to waive those applications. And true, quote, in some situations, an IJ must directly question an applicant to confirm that he understands the legal consequences of his decisions, end quote. But to the Ninth Circuit, that rule really only applies when the non-citizen doesn't have an attorney in immigration court. Or maybe if ineffective assistance of counsel is brought. Anyway, case remanded. Congratulations in part, but really in big part, to Hillary Walsh and Caitlin Lease for petitioner. And that is Troncoso-Oviedo v. Garland. Next is Chen v. Garland, published by the Second Circuit on August 5th, 2022. Like the last decision, which I recorded well before this one, this case is about motions to reopen. Mr. Chen is from China and entered the U.S. without inspection over a decade ago. In removal proceedings, he applied for asylum and related relief, basing his claim on his practice and persecution of Falun Gong in China. After some back and forth between the IJ and the BIA, an IJ conclusively denied the claim in 2014, based on a pretty strong adverse credibility finding. Mr. Chen was not removed, and he eventually married a Chinese citizen who was herself granted asylum. Mr. Chen therefore filed a Form I-730 derivative asylum petition, which was approved, because he was indeed married to an asylee. So Mr. Chen, despite it all, had a path to asylum status through his wife. Just one problem, it would seem, that final order of removal. So he moved to reopen and terminate his case so he could get asylum status before USCIS. But that same IJ from before denied it. After all, the IJ had pretty much held that Mr. Chen lied during his removal hearing in an effort to obtain asylum. Anyway, the motion was also untimely, and the IJ declined to exercise sua sponte authority to reopen the case out of discretion. Mr. Chen filed another sua sponte motion to reopen after that, and the same IJ denied again. The BIA affirmed that second denial. And the Second Circuit affirmed it all. First, it held that Mr. Chen, having become a derivative of his wife's asylum status, was not a changed country condition, such that the 90-day motion to reopen deadline could be excused. To be honest with you, I'm not 100% that Mr. Chen brought that argument to the IJ or the BIA, based on what was written in this decision at least. But in any event, the circumstance doesn't materially affect his fear of return to China, so it doesn't excuse the normal motion to reopen filing deadline. As to the IJ and the BIA's refusal to reopen the case sua sponte, well, the Second Circuit held that it can't review the issue, because it's completely at the IJ or the BIA's discretion. And according to the Second Circuit, that's the case in every circuit except the DC Circuit. They haven't spoken yet. Although the Ninth Circuit case that I just discussed. And actually, it looks like the Second Circuit does follow the same rule as the one I just discussed in the Ninth Circuit, based on its Mahmoud decision from 2009, possibly to the chagrin of the author of this decision. That is, the Second Circuit appears to be able to review and remand a sua sponte reopening denial if, quote, the agency may have declined to exercise its sua sponte authority because it misperceived the legal background and thought, incorrectly, that a reopening would necessarily fail. Indeed, Judge Pooler concurred to make this point super clear. This narrow ability to review sua sponte motion to reopen denials remains good law in the Second Circuit. Not even possibly the case here, though, according to the court. Also, the Second Circuit panel footnoted that the current injunction in the Northern District of California of the new, generally non-citizen adverse regulations promulgated under the Trump administration can't and don't bind the Second Circuit. So that's fun. The new regulations might be in effect in the Second Circuit. Any word on those new regs, Attorney General Garland, Department of Justice? And that is Chen v. Garland. Moving on. Campos-Chavez v. Garland, published by the Fifth Circuit on August 3rd, 2022. This case is exceptionally short, and it's about deficient NTAs. In fact, it's 2 pages. It seems like it's another decision in the fight between the Fifth Circuit judges who won in Rodriguez v. Garland and the judges who hate Rodriguez v. Garland. Just my opinion. Recall, in the Rodriguez decision last year, the Fifth Circuit held that if a non-citizen was ordered removed in absentia and the notice to appear that initiated those proceedings lacked the date, time, or location of the first hearing, an immigration judge needs to reopen proceedings, due in large part to the rationale employed by the Supreme Court in Pereira and Chavez and the text of INA Section 239A, the Notice to Appear statute. However, in Spagno-Bastos and then again a few weeks ago in another decision, the Fifth Circuit held that the rule that I thought was pretty clear from Rodriguez is not so clear, and that rule does not actually apply if the non-citizen received his notice of hearing after being served with a deficient NTA. Enter Mr. Campos-Chavez. He was ordered removed in absentia, moved to reopen after Pereira, had that motion denied, and moved to reconsider after Rodriguez. The BIA denied that motion to reconsider, and up to the Fifth Circuit it went. And here, the Fifth Circuit distinguished Rodriguez as follows, quote, in Rodriguez, the non-citizen received an undated NTA, but did not receive a subsequent notice of hearing because he moved. Here, by contrast, the petitioner received the NTA and does not dispute that he also received the subsequent notice of hearing, end quote. Make of that distinction what you will. Also to the Fifth Circuit, non-citizens, quote, are not entitled to Rodriguez remands where they failed to provide their address to the Department of Homeland Security, end quote. So I guess to benefit from the Rodriguez decision in the Fifth Circuit, a non-citizen must show either that they didn't receive the follow-up notice of hearing or that they provided a proper address to DHS. Or both. Nothing about non-citizen requirements to update their addresses with the court when they're served with deficient NTAs, but in any event, it seems that nearly a year after Rodriguez, and this is just to me, the Fifth Circuit is back to its pre-Rodriguez framework for in absentia motions to reopen, but just with a deficient NTA twist. Stay tuned for the next one on deficient NTA in absentia motions to reopen in the Fifth Circuit. And that is Campos-Chavez v. Garland. Next up is Matter of Fernandez, published by the BIA. That last decision was the non-citizen adverse decision on deficient NTAs this week. But as many of you know, there was another one. This one. A deficient NTA decision from the BIA, not too shabby for non-citizens. Mr. Fernandez is a lawful permanent resident from Portugal who was placed in removal proceedings for reasons unexplained. To do so, DHS served him with a notice to appear that contained the location of his first hearing, but that lacked the date and time of it, in violation of INA Section 239A. Mr. Fernandez was detained and DHS mailed him a notice of hearing later on, so that's kind of weird, but whatever. After appearing at 3 hearings pro se, Mr. Fernandez obtained an attorney who, at the attorney's second appearance, requested an opportunity to submit a motion to dismiss removal proceedings based on the deficient NTA. That's at the 5th master calendar hearing for anybody counting. The IJ declined to give that attorney that opportunity, found Mr. Fernandez removable, and then denied a subsequent motion to quash service of the NTA and to dismiss proceedings. Quite the case to tee up the issues, BIA. We've discussed the issues presented here a million times now, but again, in modern times and besides those brilliant non-citizen counsel outliers, it all really begins with the Supreme Court's discussion of NTA requirements in Pereira and then Ms. Chavez. All circuits in the BIA and the Attorney General, I believe, have held that deficient NTAs are not jurisdictional. And here, the BIA says that again. So deficient NTAs don't present grounds for non-citizens to move to terminate proceedings for lack of subject matter jurisdiction. Stop bringing those motions, they're not going to work. Just my opinion, not legal advice. But that's only the beginning. Because if compliance with the statutory NTA requirements implicates a claims processing rule mandatory upon DHS, well, the proper remedy for noncompliance might be dismissal. Similar result, different way to get there. The Seventh Circuit has been leading the way on this stuff, and here in this decision, the BIA unambiguously holds that this claims processing rule is, quote, mandatory in the sense that the rule must be enforced if it is properly raised, end quote. Thank you for the clarity, BIA. Nevertheless, as a claims processing rule, a deficient NTA issue is, quote, subject to waiver and forfeiture unless properly and timely raised by the affected party, end quote. So what is timely? The Seventh Circuit set forth a bit of a holistic approach in Ariela Ochoa v. Garland, episode 108 of the podcast. In this decision, the BIA has expressly declined that standard. Instead, the BIA declared, quote, we will generally consider an objection to a non-compliant NTA to be timely if it is raised prior to the closing of proceedings before the IJ. Such an objection may be made either orally at the hearing or in writing. Where pleadings are made in writing, the written pleading must include any objection to the absence of time or place information, or the objection will be deemed waived, end quote. All right. Caveat though, it's going to get a little hairy based on some language in this decision if the objection is done after removability has already been conceded. As it's always the government's burden to establish removability, it might be a good idea just not to concede it. That's not me, that's Ira Kurzban's motto. Don't hate me, judges. Anyway, counsel's assertion here, 5 hearings in, was timely. Woo-hoo. And get this. Agreeing with the Seventh Circuit, the BIA then held that to get proceedings dismissed under such a circumstance, the non-citizen need not show prejudice as a result of the claims processing rule violation. Big stuff, because honestly, quote, it may be difficult for respondents to demonstrate any tangible prejudice, end quote. If you say so, BIA. Prejudice doesn't matter. INA Section 239A uses the mandatory word shall to describe the NTA requirements, and Ms. Chavez was pretty firm. No prejudice required. Timely objection equals dismissed proceedings, right? Not entirely. In what I believe is a first anywhere on this issue, the BIA held that an immigration judge, quote, may allow DHS to remedy the non-compliant notice to appear without terminating proceedings, end quote. Or the IJ may not. Just saying. Not mandatory language, like shall. No guidance on when IJs should or should not terminate, but again, the BIA notes that this holding conflicts with Ariela Ochoa, which requires termination. And so this portion of the decision is not binding in the Seventh Circuit. I'd move to Chicago, but I live in San Diego. At the end of the day, quote, an immigration judge cannot simply ignore or overlook DHS's failure to include the required time or place information on a notice to appear if the issue is timely raised, end quote. Case remanded. Congratulations, Jeffrey B. Rubin, for the respondent. Gotta go back to the drawing board now on some draft motions that I've been preparing. And in case you're wondering, Appellate Judge Grant dissented strongly and would affirm the IJ, quote, in all respects, end quote, concluding by stating something that maybe I'll quote. Quote, although it does not explicitly say so, the majority ultimately reaches the same result as the outlier decision from the Seventh Circuit. See Ariola Ochoa. The majority denies this, suggesting that DHS may choose to withdraw the defective notice to appear on remand. In reality, DHS has no other choice, and the majority should acknowledge this, end quote. What is Appellate Judge Grant talking about? It's because any other, quote, cure necessarily results in termination, because there can only be one notice to appear in any given proceeding. Once DHS withdraws a non-compliant notice to appear, the proceedings end, pending the filing of a compliant notice to appear, commencing new proceedings, end quote. Gonna just leave all of that right there. Also, in case anyone was wondering, this case does not, quote, address when a mentally incompetent respondent must raise an objection to a non-compliant notice to appear, end quote. Interesting issue for another day. I'd love to get that case referred to me, if anyone is interested in so referring. And that is matter of Fernandez. Moving on then, we have Castillo-Gutierrez v. Garland, published by the Fifth Circuit on August 5th, 2022. This case is about deficient NTAs and non-LPR cancellation of removal, and in a week that just did not quit, it came out with 4 others Friday afternoon. So I didn't know about it when I discussed the last BIA case. No matter, here we go. Mr. Castillo-Gutierrez has lived in the U.S. essentially since 1990. He lives in Minnesota with his wife and 2 U.S. citizen children, but in 2014 he was placed in removal proceedings after being served with a deficient notice to appear. He appeared for his first removal hearing and he conceded removability, and he indicated that he would apply for non-LPR cancellation of removal under INA Section 248B based on the hardship that his U.S. citizen children would suffer if he were removed to Mexico. Specifically, his oldest child, 16 years old, suffers from hemophilia, and if he doesn't take his drugs, there would be big issues. Those drugs cost thousands of dollars a year, and Mr. Castillo-Gutierrez didn't know how they'd get the drug for his son if he was removed to Mexico. The son would stay here in the U.S. The IJ denied relief for quite a few reasons, and the BIA affirmed only for the failure to show that the children would suffer exceptional and extremely unusual hardship in Mr. Castillo-Gutierrez's absence. Now, Mr. Castillo-Gutierrez had also asserted that the NTA was deficient, but he hadn't really fleshed out that argument apparently, so the BIA deemed it waived. But it did discuss some aspects of it, so the Fifth Circuit did, too, a little bit. First, and a bit unsurprisingly, the Fifth Circuit rejected the argument that the deficient NTA means that the IJ lacked jurisdiction over the case. But then the court went on to explain how this was because if a non-citizen receives a follow-up notice of hearing, honestly, it seems that the Fifth Circuit doesn't really think that there's an issue. Although the Fifth Circuit discusses this issue in the context of jurisdiction rather than dismissal for a violation of a mandatory claims processing rule, it appears that the logic, at least in this case, might make the BIA decision that I just discussed, and I emphasize might, not such great law in the Fifth Circuit the day after the BIA issued its decision. At base, this is because, quote, the regulations rather than the statute govern what a notice to appear must contain, end quote. This is largely what I believe Appellate IJ Grant was saying in his dissent just now. But again, no discussion of claims processing rule violations and dismissal. This decision is all in the context of subject matter jurisdiction, which, as I just mentioned in that BIA decision, is pretty much a losing argument anywhere. Man, this stuff is getting complicated. Turning then to the BIA's finding that Mr. Castillo-Gutierrez failed to establish the sufficient hardship to his U.S. citizen children, well, despite recent favorable Fifth Circuit case law on jurisdiction, the Supreme Court even more recently decided Patel, and the Fifth Circuit here said that Patel divests it of reviewing the hardship issue. Devastating, as Patel is. Perhaps there's an argument that Patel wouldn't apply to strip the Fifth Circuit of jurisdiction if, for example, there was no dispute as to the underlying facts, and the only dispute before the court was whether those facts satisfied the legal standard of exceptional and extremely unusual hardship. Perhaps not. Undiscussed here, and the case was dismissed. And that is Castillo-Gutierrez v. Garland. Next is Chur v. Garland, published by the 8th Circuit on August 4th, 2022. Back to the 8th Circuit in what was a fairly interesting week of factual scenarios for the court. This case is about deferral of removal under the Convention Against Torture. Mr. Chur is a native of Egypt but a citizen of South Sudan. As a child, he came to the United States as a derivative on his father's previous grant of asylum in 1999. He therefore had a path to lawful permanent resident status and U.S. citizenship, but he never took it, and then later in life he received a whole bunch of arrests and convictions. Once placed in removal proceedings, he appears to have applied for special adjustment of status for asylees, and in the alternative, asylum and related relief. But the immigration judge held that, quote, his extensive criminal history since arriving in the United States made him a violent and dangerous individual, and that his Minnesota domestic assault conviction was an aggravated felony, crime of violence, end quote. That made him only potentially eligible to receive CAT deferral, which the IJ granted. But DHS appealed, the BIA reversed, and here, the 8th Circuit upheld the BIA rather than the immigration judge. So when Mr. Chur and his father were last abroad, South Sudan didn't even exist. At the time, Mr. Chur's father, quote, represented the southern region in the Sudanese parliament in 1995 and 1996 in unified Sudan's capital of Khartoum. And while serving in parliament, Mr. Chur's father came under attack from both sides. The North believed that he was a spy from the South, while the South saw his service in the Sudanese government as a betrayal. Though never harmed, he was constantly surveilled and often threatened by northern officials, end quote. He received asylum in the United States, and his family followed. So that was a bit ago. Mr. Chur now claims to fear return to South Sudan for similar reasons. But again, that country didn't come into existence until 2011. Nonetheless, quote, the party currently in power in South Sudan, the Sudanese People's Liberation Movement, is the same group that led the South during the Civil War, end quote. And Mr. Chur's father has been a vocal opponent of that government. Mr. Chur feared return mostly because of his obvious connection to his father. The petitioner here, Mr. Chur, his name is Chur, and his father's name is Chur T. Chur. Mr. Chur, the petitioner here, also fears return to South Sudan based on how that country treats people with mental illnesses, and Mr. Chur has been diagnosed with PTSD, depression, ADHD, and anxiety. Again, an IJ agreed, quote, in a lengthy analysis, end quote. But the BIA did not. So on petition to review to the 8th Circuit, the court reviews whether the BIA properly reviewed the IJ's decision, de novo. The 8th Circuit determines on its own whether the BIA properly applied that dead fish clear error standard of review when it was reviewing the IJ's decision. Here, to the 8th Circuit, the BIA properly explained why it believed the IJ was wrong. Summarized briefly, it's been a long time since Mr. Chur's father was there. Government officials and militia members have not had contact with the father in 3 decades. And the country condition evidence isn't specific enough to Mr. Chur's claims. That kind of stuff. And, although the BIA didn't actually say that it had considered all evidence of torture in the aggregate, as it must, the BIA decision, quote, demonstrates that it considered the record as a whole and accounted for all of the asserted risks in concluding that the immigration judge clearly erred, end quote. At base, quote, Personal risk of torture is a required element for cat relief, end quote. The BIA applied the correct standard of review to find that Mr. Chur hadn't shown it, and the BIA's decision wasn't so wrong that the Eighth Circuit would overturn it. Mr. Chur, therefore, lost his case. And that is Chur v. Garland. Moving on to end with the first of two 11th Circuit decisions. First, Morfa-Diaz v. DHS et al., published by the 11th on August 5th, 2022. This case is about naturalization and aggravated felonies. And honestly, as you've already gathered if you've gotten this far, it's a monster week, and I'm literally in the middle of moving. By the time you hear this, I will have been moved. The future. So I'm going to cut to the chase. LPRs are eligible to naturalize to U.S. citizenship after a certain amount of years, but they're not allowed to naturalize if they don't have good moral character. And wouldn't you know it, we just discussed that like 4 cases ago. One of the other statutory good moral character exclusions is at INA Section 101F8, a conviction at any time for an aggravated felony. Long story short, USCIS believed Mr. Morfa-Diaz's conviction was an aggravated felony. A district court judge agreed when he sued USCIS, and the 11th Circuit has now agreed too. His conviction was from 1996, and it's attempted sale of a controlled substance in the 3rd degree under New York Penal Law Section 220.39. The substance was cocaine, but the categorical approach applicable to aggravated felony drug trafficking offenses at INA Section 101A43B doesn't care about that just yet. The first inquiry is, does the New York crime cover more drugs than the Federal Controlled Substance Act? If it does, the New York crime is overbroad vis-a-vis an aggravated felony, and it might not be an aggravated felony that bars Mr. Morfa-Diaz from naturalizing. But actually, the statute might not be overbroad. It might not have covered more drugs than the federal CSA. At least at the time of Mr. Morfa-Diaz's New York conviction in 1996, which is the relevant period of inquiry when comparing criminal statutes to removability provisions. Make sure you make that argument correctly. The 11th Circuit implies here that comparing the removability provision to the criminal statute definition in effect at the time of the argument, rather than at the time of the conviction, is near sanctionable conduct. At least in federal court. In any event, the 11th Circuit found that the New York crime was divisible, meaning that the 11th Circuit could go and see which subsection Mr. Morfa-Diaz was actually convicted of. And in 1996, that subsection, subsection 1, was defined to only cover drugs that are also covered under the Federal Controlled Substance Act. That is, subsection 1, the subsection of conviction, criminalized attempted sale of only narcotics. In 1996, apparently the federal definition of narcotics was the same as New York's. The 11th Circuit determined that Mr. Morfa-Diaz was in fact convicted of a subsection 1 offense, because in his plea colloquy and in his indictment, it listed that he attempted to sell a narcotic drug. Mr. Morfa-Diaz therefore can never naturalize ever because his conviction is an aggravated felony. Heck, he might be removable too. Although maybe not if his pre-1997 crime here didn't match an aggravated felony at the time of conviction in 1996. I don't know when INA Section 101A43B came into effect. Check Ira's book. An analysis for another day and another case. Judge Wilson concurred in one sentence, quote, "I concur in result," end quote. And that is Morfa-Diaz v. DHS et al. That leaves us with Bastias v. U.S. Attorney General, published by the 11th Circuit on August 2nd, 2022. This case is about crimes of child abuse, child neglect, or child abandonment within the meaning of the removability provision at INA Section 237A2EI. And really it's a challenge to the BIA's decision on that same issue in matter of Saram and matter of Velazquez-Herrera. Because in those decisions, the BIA held that a criminal statute that permits conviction with the mental state of merely culpable negligence, also known as criminal negligence, will likely satisfy the immigration definition used at INA Section 237A2EI. Mr. Bastias is an LPR but pled guilty to a Florida statute section 827.032 charge titled, quote, abuse, aggravated abuse, and neglect of a child, end quote. So not a great start to challenge removability, but also, titles aren't dispositive. The record is apparently unclear what subsection Mr. Bastias pled guilty to, and it's DHS's burden to establish removability. Remember that. But in this case, everyone agrees that the least culpable way to commit the crime is with a mental state of criminal negligence. That is, quote, culpably negligent child neglect that doesn't cause significant injury, end quote, which punishes at a minimum a failure to, quote, make a reasonable effort to protect a child from abuse, neglect, or exploitation by another person, end quote. Restated, it doesn't matter to the 11th Circuit what Mr. Bastias was actually convicted of. The court has identified the least culpable conduct criminalized by the Florida statute, and that is what the categorical approach is all about. The IJ and the BIA held that that crime, that least culpable conduct, made Mr. Bastias removable. What say you, 11th Circuit? Well, under BIA precedent, a crime of child abuse, neglect, or abandonment describes a unitary concept, and it's satisfied by a crime that, quote, doesn't require actual harm or injury to a child if the defendant's mental state was greater than common law negligence, and there is proof of a likelihood or reasonable probability that a child will be harmed, end quote. Mushy, I know. Again, the least culpable conduct criminalized by the Florida statute here satisfies that mushy definition. So, the dispute to the 11th Circuit comes down to whether the lessened mental state that the BIA said will satisfy Section 237A2EI in Saram and Velazquez-Herrera is kosher. But there's a big problem right off the bat for Mr. Bastias, because in 2018, the 11th Circuit held by a published decision that the INA Section 237A2EI, crime of child abuse, neglect, or abandonment, statutory definition, is ambiguous. The 11th Circuit made that holding succinctly, but that means that under the Supreme Court's Chevron decision, the 11th Circuit must defer to the BIA's definition of this removability statute, so long as the BIA's definition of the phrase in Saram and Velazquez-Herrera is reasonable. The 11th Circuit held here that it was reasonable. It didn't matter to the court that, as the 10th Circuit has reasoned, only 11 states in 1996 criminalized child abuse crimes with merely criminal negligent mens reas or less. And the reason it didn't matter to the court is because under Chevron, quote, we are not looking for the best interpretation or the majority interpretation, only a reasonable one, end quote. The BIA is holding that INA Section 237A2EI can make a non-citizen removable where the criminal statute permits a merely criminal negligent mental state is reasonable to the 11th Circuit. In so holding, the 11th Circuit has furthered a circuit split on whether or not Saram and Velazquez-Herrera deserve deference, with at least the 10th Circuit in Ibarra v. Holder from 2013, and maybe the 9th Circuit, depending on what the 9th does with Diaz-Rodriguez v. Garland on en banc rehearing. Good enough for me. Notably, while reviewing how states criminalized crimes is quite instructive to ascertain the federal removal definition of all these statutes we're always talking about on the podcast, the Supreme Court has, quote, never suggested that an administrative agency must employ that method, end quote. Restated, it's important to see how states defined these removability provisions when they were implemented under the INA, usually in 1996. But the BIA doesn't have to do that. The BIA has other tools that it can use to define these ambiguous statutory terms. The 11th Circuit went on to explain how the BIA's definition doesn't contradict the text of INA Section 237A2EI or common law understandings of child abuse or neglect, which would be unreasonable indeed, and it deferred to the BIA precedent. All that means Mr. Bastias is removable. Judge Newsom, who wrote the majority opinion, then concurred with himself. Love when that happens. To essentially say that while the panel is bound by that 2018 decision finding this removability provision ambiguous, the 11th Circuit might have jumped the gun back then and issued its decision without providing enough analysis. C'est la vie. Later panels are bound by prior ones. Here's one final note. Just thought I'd read this, as it amused me, and given the Supreme Court's recent holding in Perez, that at the relief stage during immigration court proceedings, an ambiguous criminal conviction record might bar a non-citizen from remaining in the U.S. That is, under Perez, at the relief stage, ambiguity is going to be held against the non-citizen. So here's this from the 11th, quote, "The transcript of Mr. Bastias's plea colloquy is hopelessly opaque. The judge stated that he would adjudicate Mr. Bastias guilty of the charge of aggravated child neglect, a felony of the 3rd degree, so it's a lesser included offense of what he was originally charged with. When the clerk asked for the statute number, the judge said, 'Oh, I don't know.' One of the lawyers suggested 827, and the judge responded, 'Whatever.'" End quote. Such is the morass non-citizens might need to traverse to remain in the U.S. if removability is established for another reason and they're applying for relief. Peek footnote 2, though, to see why, had the least culpable conduct here been less, DHS would have lost and Mr. Bastias would not have been removable due to this ambiguous criminal conviction record. Because again, DHS has the burden here. And that is Bastias v. U.S. Attorney General. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.